Under Minnesota law, child support is calculated on both parties' gross income before taxes are deducted. And gross income can sometimes be easily determined in the case of a W-2 wage earner. For someone who's self-employed or engaged on a commission basis that has wildly fluctuating income, it could be more of a challenge. There are also those cases where someone is unemployed or underemployed, not working at all or not working on a full-time basis. And in those situations, the court can establish potential income for purposes of child support. Those numbers are then entered into a calculator, which is an online resource available to anyone, and child support can be calculated. The more important ingredient then has to do with the amount of parenting time awarded to each party. Under current law, there are 3 different categories of parenting time that then relate to what's known as a parenting expense adjustment. Other expenses such as the cost of health and dental insurance for the children and the cost of work-related child care would also be entered into the child support calculator to render a result. So it then takes 3 forms: basic support, which is a specific amount paid per month; medical support, which is an amount paid toward the cost of the children's health and dental insurance; and then work-related child care support. There's a 4th category that's not contemplated in the calculator but frequently included, and that relates to the division of extracurricular and other extraordinary expenses. This day and age, when sign-up fee for soccer or football or music lessons gets to be pretty significant, it's not unusual for those to be contractually agreed upon between the parties and divided between them on some basis. The subject of spousal maintenance is probably the most controversial issue I deal with, either as a lawyer or as a neutral mediator or early neutral evaluator. Just the emotion related to the concept of spousal maintenance makes it a difficult case in and of itself. But above and beyond that, we have to consider both parties' available resources, their budgets, what's reasonable and necessary to support themselves in terms of the standard of living during the marriage, and what's the other party's ability to make up for that difference. So most simplistically, I think of, does the party have a need? Do they have an ability to meet that need through their own resources? And if they do not, does the other party then have the ability to fill in that gap and supplement the income along the way? Failure to pay court-ordered child support and spousal maintenance can be met, worst-case scenario, with a contempt of court action, where a party can actually face incarceration, jail time for non-payment of those obligations. Other remedies include entering judgment against those individuals, other legal resources that are available to make sure that the support is paid as due, when due, so there aren't significant arrearages that can erupt.